Hello, hello, hello on mic testing. Hello on the Republic Day. We are gonna read the Constitution of India. Procedure generally, Article 118. Is my voice coming or not? I'm gonna check it. Procedure generally, Article. Okay, my voice is coming. It is too much. I'm gonna reduce it. Ah, Article 118, Rules of Procedure. Clause 1. Each House of Parliament may make rules for regulating, subject to the provisions of this Constitution, its procedure and conducts of business. Clause 2. Until rules are made clear. Clause 1. The rules of procedure and standing orders in force immediately for the commencement of this Constitution with respect to legislature of Dominion of India shall have effect in relation to Parliament in subject to such modification and adaptation as may be made therein by Chairman of the Council of States or the Speaker of the House of the People, as the case may be. Okay, okay. The President, after consultation with Chairman of the Council of the States and the Speaker of House of the People, may make rules as to the procedure with respect to joint sitting of and communication between the two houses. Okay. Clause 4. At joint sitting of the two houses, the Speaker of the House of the People, or in his absence, such person as may be determined by rules of procedure made under Clause 3 shall reside. Okay. I don't think this law concerns me. This is how are the rules of procedure. Means mean which means that both houses have uh powers to regulate the constitution and its provisions. So yeah, these laws are not interest of me. So Article 119, Regulation by law procedure in Parliament in relation to financial business. Okay, it is gonna be between relation to financial business regulation by the Parliament. Parliament, for the purpose of the timely completion of financial business, regulate by law the procedure of and the conduct of business in each House of Parliament in relation to any financial matter or to any bill for the for the appropriation of monies out of the consolidated fund of India, and if so far as any provision of any law so made is inconsistent with any rule made by House of Parliament under clause 1 of Article 180 or with any rule standing order having effect in relation to Parliament under clause 2 of the article, such provision shall prevail. Okay. Constitution of India, Part 5, the Union. Okay. Languages. Maybe this is the matter I am more concerned with over the last few uh, articles. Article 120, language to be used in Parliament. Clause 1, notwithstanding anything in part. I mean, what is this, man? This is 10, this is 5, and this is 2. Is this 125? Or I don't know. Look, I will check it. I don't know the Greek number system. 17 in Roman numerals. Oh, sorry, it is Roman. Okay. It is 70. I mean, you can just write the 17, man. Why print in this way? Notwithstanding anything in the part 17, but subject to the provisions of Article 348, business in Parliament shall be transacted in Hindi or in English. Okay, so there can be only two languages that will be used in Parliament, English and Hindi, provided that the chairman of the Council of State or the Speaker of the House of the People or person acting as such, as the case may permit, any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. Okay, so the chairman of the council, Rajya Sabha ka chairman and Lok Sabha ka speaker can grant you the permission to speak in your native tongue or mother tongue, whatever you call it. I mean, okay, like I think this should be default. Like it's fine somebody speaks in their mother tongue instead of giving them permission. Otherwise, if the permission is not given, they cannot speak in their mother tongue, which is extremely stupid. Uh, Clause 2 of Article 120, unless Parliament by law otherwise provide, article shall, after the expiration of period of 15 years from the commencement of this constitution, have effect as if the words or in English were omitted therefrom. ये क्या बोल रहा है भाई आर्टिकल were omitted therefrom. Okay, so okay, this is very good, man. Okay, so this clause 2 of Article 120 says that after the 15 years, when the article is in, sorry, the constitution has been effect, the parliament can change it by law, which is interesting. I don't know if they have changed it or not. Like, oh, wait. Is it saying that Only the or in English. That means the only option is now in Hindi, and Hindi has been universalized in India. If they if this is saying that, then this is extremely this constitution have effect as it unless Parliament by law otherwise provide this article after the expiration of period of 15 years from the commencement of this constitution have effect as if the words or in English were omitted thereof from. Okay, so indirectly this is saying that English is not any much mandatory. Only Hindi is. I mean, it is saying that only, na. Like Hindi has taken even superior to the English now. Importance. Article 121 Restriction on discussion in Parliament. No discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of High Court in the discharge of any judge of the Supreme Court or of High Court in the discharge of his duties, except upon a motion for presenting an address to the President praying for the removal of the judge as herein after provided. Okay, so you cannot talk about Supreme Court judges and the duties or judgments he is gonna pass. Okay, in the Parliament, unless you want to remove it. Okay, this is giving lots of power to the judge. 122 article courts not to inquire into proceedings of Parliament. The validity of any proceeding in Parliament shall not be called in question on the ground of any alleged irregularity of procedure. Okay, I don't know, man. So, okay, so this is like ये लो भाई कोर्ट तुमको भी पावर दे देता हूँ. Take this power to you. But here the court power of the courts is also limited. So it is made in the such a way that it is made in a such a way that the courts are not all powerful nor the parliament is. Courts not to inquire into proceedings of the parliament. The validity of any proceedings in parliament shall not be called in question on the ground of any alleged irregularity of procedure. Clause 2 of Article 122. No officer or member of parliament in whom powers are vested by or under this constitution for regulating procedure or the conduct of business for maintaining order in parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Okay, these are the powers given to the officers and members of parliament that court cannot question their maintenance and this the parliament attack happened by the done by the terrorist cannot be questioned in court. No, the security and the measurements that are obviously failed if the attack is happened, then it cannot be questioned in the court. They are not, cannot be questioned. Legislative powers of the president. Article 123. Power of president to promulgate ordinances during recess of parliament. Okay. I never heard the word promulgate, man. And is this calling to the literally recess like break? Okay. To promulgate ordinance during recess of parliament. Clause 1. If at any time except when both houses of parliament are in session, the president is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him to require. Clause 2. An ordinance promulgated under this article shall have the same force and effect as an act of parliament, but every such ordinance. Okay, so president also can promulgate ordinance. Clause subclause 2A of Article 123 shall be laid, but every such ordinance shall be laid before both houses of parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of parliament, or if before the expiration of the period, resolutions disapproving it are passed by both houses upon the passing of the second, those legislation and may be withdrawn at any time by president. Explanation: where the houses of parliament are summoned to reassemble on different days, the period of 6 will shall be reckoned from the later of those dates for the purposes of this clause. If and so far as an ordinance under this article makes any provision which parliament would not under this constitution be compelled to intact, it shall be void. Okay, I really didn't understand what is written here. I seriously didn't understand what is written. Okay, so the this article is more of like, the president can pass on new things if it is necessary, but it can only last for 6 weeks. Okay, okay, okay. Okay, it also cannot violate the fundamental rights, and it must, before the passing of ordinance, it must be laid before both of the houses of the parliament, and it can be only done for 6 weeks, and maximum like life is 6 months and 6 weeks, and the president can withdraw the ordinance at any time. Okay, okay, understood. So the Union Judiciary, Article 124. Establishment and Constitution of Supreme Court. There shall be a Supreme Court. Okay, okay, this is important, I guess. There shall be a Supreme Court of India consisting of Chief Justice of India, and until Parliament by law prescribes a larger number of not more than 7 other judges. So the limit is 7 judges, huh? Okay, okay. For Chief Justices of India. Eh, No, I think there is only one Chief Justice and there are other 7 judges who each also can sit with him to give judgments, I guess. Because there is only one chief. There cannot be 7 chiefs. It is stupid. Chief means head. Because there can be only head. One head. Just like there is only one Chief Justice of India now, that is Justice Gawai. The other judges also sit with him, but they do not have the same powers as him, I guess. Clause 2. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the National Judicial Appointments Commission referred in Article 124A and shall hold office until he attains the age of 65 years. Oh, okay, okay, okay. I mean, you should also have made this for the Prime Minister and President that they also can only attend this position before they are 65 years, not after 65 years. You should also made this, man, but okay, it's okay. The judges are usually much more well read and you know smarter than the prime ministers. Subclause A of clause 2 of Article 120. A judge may, by writing under his hand, address to the president, resign his office. Okay. B. A judge may be removed from his office in the manner provided in clause 4. In his 38th amendment, provided that in the case of appointment of a judge other than Chief Justice, the Chief Justice of India shall always be consulted. This amendment has been struck down by Supreme Court in the case of Supreme Court Advocates on Record Association and other versus Union of India in its judgment dated 16/10/2015. Okay. Provided further that this amendment has been struck down by Supreme Court in the Supreme Court Advocates on Record Association and other versus Union of India judgment dated. Oh man. Article 2A. The age of judge of the Supreme Court shall be determined by such authority and such in such manner as Parliament by law provide. Article 124 of Article 120 Clause 3. A person shall not be qualified for appointment as judge of the Supreme Court unless he is citizen of India and has not subclause A has been for at least 5 years a judge of High Court or of two or more such courts in succession, or B has been for at least 10 years an advocate of High Court or two or more such courts in succession, or C is in the opinion of the President a distinguished jurist. I mean, what is the difference between judge and jurist? Let's see. An expert or In or writer on law. Okay, so judice is also. Explanation 1. In this clause, High Court means a High Court which exercises or which at any time before the commencement of this Constitution exercised jurisdiction in any part of the territory of India. Okay. Explanation 2. In competing for the purpose of this clause, the period during which a person has been an advocate, any period during which a person has held judicial official not inferior to that of a district judge after he became an advocate shall be included. Okay. Clause 4 of Article 124. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than two-thirds of members of that House present and voting has been presented to the President in the same session for such removal on the ground of rude misbehavior or incapacity. So basically, removing the judge is not a easy thing. You need a two-thirds majority in both of the houses of the parliament. Okay, so it is not gonna be easy thing. I think the current Modi government doesn't have third of majority. They only have something like half of the majority. Two-third means more than two-third means more than 60-70% of majority, I guess. Modi only has now like something closer to 60%. So Modi really cannot remove the Supreme Court judge. Okay, this is a good thing, man. This limits the power of the Prime Minister and ruling party. Unless, obviously, they have gotten such a majority, then they are pretty much very powerful. And you have gotten such a majority in the country, then you get the powers, man. Clause 5 of Article 124. Parliament by law regulate the procedure for the presentation of an address and for the investigation and proof of the misbehavior or incapacity of a judge under Clause 4. Okay. Clause 6 of Article 124. Every person appointed to be judge of the Supreme Court shall, before he enters his office, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Okay, so the judge also takes oath. Oath taking in a like is such an important thing. But does oath taking really do anything, man? Like I take the oath to be truthful and give unbiased judgments. I take the oath to be truthful and give unbiased judgments. Like really, is this how people operate? Like, oh, I may, as a police, I take the oath to be truthful and uncorrupt and serve the people. And like, no, they don't behave in that way after they taken the oath. Okay, I can understand the symbolic meaning for it, but it is pretty much useless. The oath taking things. Clause 7. No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. Okay, okay, okay. Okay, okay. So this is like once you are a you know judge of the Supreme Court. Uh, okay, they cannot be uh, you know lower judges or anything of that matter once they have been retired as a judge of the Supreme Court. And I mean, okay, many judges have given entry into the political parties after they have left the courts, high courts and Supreme Courts. This is extreme. This is extremely funny, man. Article 124A, National Judicial Appointments Commission. There shall be commission to be known as the National Judicial Appointments Commission, consisting of the following, namely, there shall be a commission to be known as a National Judicial Appointments Commission, consisting of the following, namely, A. The Chief Justice of India, Chairperson ex officio. Okay. Clause B. Two other senior judges of the Supreme Court next to the Chief Justice of India, members ex officio. The Union Minister in charge of law and justice, member ex officio. D. Two eminent persons to be nominated by the community, consisting of the Prime Minister, the Chief Justice of India, and the leader of opposition in the House of the People, or where there is no such leader of the opposition, then the leader of single largest opposition party in the House of the People members. Okay, I think that is, like there are two other eminent members which are randomly chosen in this nation. It will be a random mathematic thing that will be go and we will choose this person. How will that be the thing there? Instead of this, chosen by Prime Minister, Chief Justice, and the leader of opposition in the House of the People, or where there is no such leader of opposition than the leader of single largest opposition party in the House of the People members. Provided that one of the eminent person shall be nominated from amongst the persons belonging to the scheduled caste, the scheduled tribes, other backward classes, minorities, or women. Okay, so there provided further that an eminent person shall be nominated for a period of 3 years and shall not be eligible for renomination. Okay. Clause 2 of Article 124A. No act or proceedings of the National Judicial Appointments Commission shall be questioned or be invalidated merely on the ground of the existence of any vacancy or defect in the constitution of the commission. Okay. Article 124b. Functions of commission. It shall be the duty of the National Judicial Appointments Commission to. Okay, I mean, like if you go by this, the Chief Justice of India, the ruling party doesn't have much say in here. The Chief Justice of India. Okay, the Chief Justice of India can act in his own manners. The two other judges of the Supreme Court can also do the same. The Union Minister, okay, this is one in from the ruling party. And this like Prime Minister, Chief Justice of India. So they don't have that much of a power in the appointment of in the Judicial Commission of India. Article 124B Functions of Commission. It shall be the duty of the National Judicial Appointments Commission to respond, recommend person for the appointment as the Chief Justice of India, judges of Supreme Court, Chief Justice of High Courts, and other judges of High Court. We recommend transfer of Chief Justice and other judges of High Courts from one High Court to any other High Court, and C. Ensure that the person recommended is of ability and integrity. Okay, so they decide the appointment of Chief Justice of India, judges of Supreme Court, and other High Courts. They don't decide the appointment of judges of district courts, I guess. There is something like other method for that. Obviously, these High Court judges will be picked by the election from the district judges. Article 124C Power of Parliament to make law. Parliament by law regulate the procedure for the appointment of Chief Justice of India and other judges of the Supreme Court and Chief Justice and other judges of High Courts, and empower the Commission to lay down by regulations to procedure for the discharge of its function, the manner of selection of person for appointment, and other matters as may be considered necessary by it. Article 125 Salaries etc. of judges. There shall be paid to the judges. Okay, wait, I will check this. 124, Article 124C. Because I really don't understand it, man. Seems like it is heading towards. Yeah, it is introduced in Constitutional Amendment Act of. So Article 124C is a new article, and it is introduced by. Okay, so this is like increasing the power of the parliament and decreasing the power of the courts. The 99th Amendment and the Article 124C were struck down by the Supreme Court in 2015, upholding the validity of collegium system. Okay, so this judgment were struck down. Why are they? 1 year. If these articles were. Yeah, I think the collegium system is better than the NJAC system they are trying to provide. Uh, Article 125 Salaries etc. of judges. There shall be paid to the judges of the Supreme Court such salary as may be determined by Parliament by law and until provision in that behalf is so made. Such salaries are specified in the second schedule. Okay. Okay, we will check how much are the salaries of the judges. Current judges, how much salary they get? The Chief Justice of India earns roughly around 3 lakh and other High Court Chief Justices earn uh, 2 lakh 50,000 monthly and High Court judges receive 2 lakh 25,000. Okay, that is I think more than enough and good salary. Okay. Two, every judge shall be entitled to such privileges and allowances and to such rights in respects of leave and of absence and pension as may from time to time be determined by or under law made by Parliament and until so determined to such privileges, allowances and rights as are specified in the second schedule. Okay. Provided that neither the privileges nor the allowances of a judge nor his rights in respect of leave of absence or pension shall be varied to his disadvantage after his appointment. Okay, okay. Article 126 Appointment of Acting Chief Justice. When the office of Chief Justice of India is vacant or when the Chief Justice is by reason of absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the president may appoint for the purpose. Article 127 Appointment of ad hoc judges. If at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, the National Judicial Appointments Commission on a reference made to it by Chief Justice of India may with the previous consent of the President and after consultation with the Chief Justice of High Court concerned request in writing the attendance at the sittings of the court as an ad hoc judge for such period as may necessary of a judge of a high court duly qualified for the appointment as a judge of the Supreme Court to be designed by the Chief Justice of India. Clause 2 of Article 127. It shall be the duty of the judge who has been so designated in priority to other duties of his office to attend the sittings of the Supreme Court at the time and for the period for which his attendance is required. While so attending, he shall have all jurisdiction powers and privileges and shall discharge the duties of the judge of the Supreme Court. Okay, so this is appointment of ad hoc judges means like this is when you have to appoint the judges very quickly. You can summon the judges from lower courts which are taken into consideration by within the consent of the president and he can the Supreme Court of India and its chief justice can appoint ad hoc judges. Yeah, so I think the quorum, if there are not judges in Supreme Court, the Chief Justice of India can ad hoc hire judges. Okay, okay. Article 128 Attendance of retired judges at the sittings of the Supreme Court. Notwithstanding anything in this chapter, the National Judicial Appointments Commission may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or the Federal Court, or who has held the office of a judge of a High Court and is duly qualified for appointment as a judge of the Supreme Court to sit and act as a judge of the Supreme Court, and every such person shall, while so sitting and acting, be entitled to such allowance as the President may, by order, determine, and have all the jurisdiction, powers, and privileges of, but shall not otherwise deem to be a judge of that court. Okay, so a retired judge can be summoned, but he will not be considered a judge of that court, but will have lots of powers, like all the powers of jurisdiction, powers, and privileges. Okay. Okay, this article. Okay, so like Modi government after coming in power, made lots of amendments with the how the hiring of the Chief Justice of India is done. But the Chief Justice of India had the power to struck it down. So I think they have stuck it down, and okay, that's good, man. Provided that nothing in this article shall be deemed to require any such person or as appropriate to sit and act as a judge of that court unless he consents to do. Okay, so the person has to give his consent if he has to come back. Obviously, it is not forceful. Article 129 Supreme Court to be a court of record. Okay, the Supreme Court shall be a court of record and shall have all the powers of such court, including the power to punish for contempt of itself. Okay, Supreme Court. I mean, the Supreme Court can punish itself, really? This is this is another funny law after the alien law. Okay, so the Supreme Court can, pun- uh, you know, oh man. Okay, okay, okay. Article 130, Seat of Supreme Court. The Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. Okay, Supreme Court of India can sit anywhere in India if the President and Chief Justice of India want. Article 131. Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the court shall, to the exclusion of any other court, have original jurisdiction in any dispute. A. Between the government of India and one or more states, or between the government of India and any state or states on one side and one or more other state on the other, or between two or more states. Okay, the Supreme Court has power to make judgments on matters of between the two states. I guess make jurisdictions between one state versus other state, government versus the state, like government of India versus the government state of the Kerala, something like that. If and insofar as the dispute involves any question, whether of law or fact, on which the existence or extents of legal right depends, provided said jurisdiction shall not extend to dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument which having been entered into or executed before the commencement of this constitution. Continues in operation after such commencement, or which provide that the said jurisdiction shall not extend such dispute. Article 131A. Exclusive jurisdiction of the Supreme Court in regard to question of constitutional validity of central laws omitted by the Constitution 43 amendments. Okay, I don't know, man. Article 132. Appellate jurisdiction of the Supreme Court in appeals from high courts in certain cases. Clause 1. An appeal shall lie to the Supreme Court from any judgment, decree, or final order of High Court in the territory of India, whether in civil, criminal, or other proceedings. If the High Court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of this Constitution. Okay, so like seems like the high courts are looking over to Supreme Court if the something of uh, okay, this like the high courts looking over to Supreme Court and the Supreme Court's power being supreme and unquestionable by other high courts. where such a clause 3, where such a certificate is given, any party in the case may appeal to the Supreme Court on the ground that any question, as aforesaid, has been wrongly decided. Okay, so like it is very very common that your judgment is given against you in the High Court. You can appeal to the Supreme Court. Explanation: for the purpose of this article, the expression of final order includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. Okay. Appellate. Article 133. Appellate jurisdiction of the Supreme Court in appeals from high courts in regard to civil matters. Clause 1. An appeal shall lie to the Supreme Court from any judgment, decree, or final order in civil proceeding of High Court in the territory of India, if the High Court certifies under Article 134A. Subclause A of Clause 1 of Article 133. That the case involves a substantial question of law of general importance, and B. That in opinion of the High Court, the said question needs to be decided by the Supreme Court. Clause 2 of Article 133. Notwithstanding anything in Article 132, any party appealing to the Supreme Court under clause may urge as one of the ground in such appeal that substantial question of law as to the interpretation of this constitution has been wrongly decided. Okay. Clause 3. Notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provide, lie to the Supreme Court from the judgment, decree, or final order of one judge of High Court. Okay, I really didn't understand this. I will check it. The English written is extremely complex here, man. I am learning word the words I never heard, like appellant. I never heard the word appellant. Okay. Okay, guys. I am really tired. We will stop at Article 133 and we will continue our reading from Article 134. Bye bye. Take care.